Good evening, beautiful people. Thank you so much for joining us this evening. I hope you're having a fantastic day and week. Welcome to our live weekly YouTube readings of the final report of the California Reparations Task Force right here on the CJEC YouTube channel. This is the only live reading of the California Reparations Task Force's final report on YouTube. The final report of the first in the nation California Reparations Task Force is one of, if not the, most important government reports about the Black American community since the 1960s. Equally important, it's also the foundation for current and future reparations legislation in California. The report is nearly 1,100 pages long, and we're bringing you every page of it, chapter by chapter, every week on Thursdays at 7 p.m., so that you are properly educated in your advocacy for reparations in California. Today's reading of the final report is presented to you as a community service with support from the Reparations Organizing and Mobilizing Team at the Coalition for Just and Equitable California, CJEC. CJEC is California's leading grassroots organization born for reparations and reparative justice for Black American freedmen living in California. For more information on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. slavery, the Act to End Current Slavery in California State Prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. Before we go any further, right now, I ask you to do three things. Like this video, hit the bell for reminders, and subscribe to our YouTube channel. After we're done reading tonight, I'll ask you to do three more things. Get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, and X, formerly known as Twitter, at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and information on our Get Involved page. Get involved. Support our work by volunteering and/or donating. To donate, just click the Donate tab on the home page of our website. A special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. They are a 501c3 organization. Learn more about their outstanding work at www.cabwhp.org. By way of introduction, my name is Raphael H. Plunkett. I live in Southern California. I'm originally from Chicago, and I'm a volunteer reparations advocate with CJEC's Reparations Organizing and Mobilizing Team. The agenda for today, Chapter 15, Examples of Other Reparatory Efforts, of the final report of the California Reparations Task Force. We continue Part 3, Domestic Reparatory Efforts. We resume on page 584, Virginia Eugenics. You can follow along in the reading, download tonight's chapter, or the full final report yourself by going to our website at www.cjec-official.org/reports. Okay, we're about ready to start our reading, but before we do, I have some special thanks and announcements to make. First, as always, I would like to thank our good friends at ETM Media Group on YouTube for their live readings of the first California Reparations Report. You can watch their readings of the first report on their channel at ETM Media Group on YouTube and on our website at www.cjec-official.org/videos. Today's sponsors are the Bell and Plunkett families. I volunteer with CJEC for our ancestors, our elders, myself, our children, our grandchildren, and our community. Third, for those of you who don't know, historic reparations legislation in California is here, and more is coming. SB 490 is California's first lineage-based reparations-related legislation to establish the California American Freedmen Affairs Agency. The bill was introduced by State Senator Stephen Bradford and will move forward in 2024. To read the bill, visit www.cjec-official.org/advocacy. Fourth, as mentioned, more historic reparations bills are coming. Over the next several months, more reparations bills will be written. During the 2024 legislative session, we'll see those bills introduced and start moving toward passage by majorities of both the California State Assembly and Senate. To pass reparations bills in 2024, we need 41 Assembly members and 21 senators to say yes. When those bills are passed, we need our governor to sign the bills. So, to make reparations a reality in California, the math is 41 plus 21 plus 1. That's 41 Assembly members, 21 senators, and 1 governor. 41 plus 21 plus 1 equals reparations in California. Last but not least, a special thank you to CJEC's Reparations Organizing and Mobilizing Team, specifically our volunteer final report readers. And I personally extend gratitude to Chris Lodgson for his leadership and focus. And without further ado, Chapter 15 of the California Reparations Task Force's final report. Virginia Eugenics. On May 2, 2002, 75 years after the Buck v. Bell Supreme Court decision that upheld Virginia's eugenics statute, Virginia Governor Mark R. Warner issued an apology for the state's embrace of eugenics and denounced the state's practice that involuntarily sterilized persons confined to state institutions from 1927 to 1979. In 1924, Virginia passed its Eugenical Sterilization Act, which authorized the sexual sterilization of inmates at state institutions. The act provided that the superintendent of the Western, Eastern, Southwestern, or Central State Hospital or the state colony for epileptics and feeble-minded could impose sterilization when he had the opinion that it was for the best interest of the patients and of society that an inmate of the institution under his care should be sexually sterilized and the requirements of the act were met. The act responded to 50 years of scholarly debate over whether certain social problems, including shiftlessness, poverty, and prostitution, were inherited and ultimately could be eliminated through selective sterilization. The act was passed alongside the Racial Integrity Act, which banned interracial marriage by requiring marriage applicants to identify their race as, quote, white, end quote, colored, end quote, or, quote, mixed, end quote, with, quote, white, end quote, being defined as a person who, quote, has no trace whatsoever of any blood other than Caucasian, end quote. The Racial Integrity Act was bolstered by the eugenics efforts like the Eugenics Sterilization Act, which saw non-white people as having inferior genes. One inmate, Carrie Buck, appealed her order of sterilization, but U.S. Supreme Court upheld the Virginia state law in Buck v. Bell, 1927, by a vote of 8-1. The controversial ruling was never overturned, but the law was repealed in 1974. Between 1927 and 1972, about 8,300 Virginians were sterilized. In 1980, the American Civil Liberties Union sued the Lynchburg Training School and Hospital, previously the Virginia State Colony for Epileptics and the Feeble-Minded, on behalf of the men and women who had been sterilized there. In Poe v. Lynchburg Training School and Hospital, 1981, the U.S. District Court for the Western District of Virginia ruled that while sterilizations had been legal, there was cause to believe that correct procedure had not always been followed. The plaintiffs later settled with the state out of court, with the state agreeing to inform women what had been done to them and to provide them with counseling and medical treatment. In 2013, Virginia House member Robert G. Marshall introduced House Bill 1529, the Justice for Victims of Sterilization Act. The bill, as introduced, would have provided compensation in the amount of $50,000 to persons involuntarily sterilized between 1924 and 1979. Funds would be administered by the Department of Social Services. The provisions of the bill would expire July 1, 2018. The bill, however, never left the House and died in appropriations by February 2013. In 2014, Virginia House member Robert G. Marshall reintroduced the Justice for Victims of Sterilization Act as House Bill 74. The bill included an updated sunset of July 1, 2019. The House Bill 74 was referred to the Committee on Appropriations but was voted on to be continued in 2015. In 2015, Virginia House member Patrick Hope reintroduced the Justice for Victims of Sterilization Act as House Bill 1504. The bill remained the same and included a sunset provision. The House assigned House Bill 1504 to the General Government and Capital Outlay Subcommittee, but by February 2015, the bill was left in Appropriations. The same year, Virginia House member Benjamin Klein introduced an identical bill, House Bill 2377. However, House Bill 2377 was left in Appropriations in February 2015. Despite both bills not making it out of Appropriations, an amendment was added to the 2015 House Budget Bill, HB 1500, to allocate $400,000 from the State General Fund for compensation to individuals who were involuntarily sterilized pursuant to the Virginia Eugenical Sterilization Act and who were living as of February 1st, 2015. As written in the budget, the funds were to be managed by the Department of Behavioral Health and Developmental Services and limited to $25,000 per person instead of the proposed $50,000. Furthermore, should the funding provided for compensation be exhausted prior to the end of the fiscal year 2016, the department was ordered to continue to collect applications. The department was required to provide a report to the governor and the chairman of the House Appropriations and Senate Finance Committees on a quarterly basis on the number of additional individuals who had applied. The Virginia House and Senate approved House Bill 1500, and the bill was signed by the governor on March 26, 2015, establishing the Virginia Victims of Eugenics Sterilization Compensation Program, VESC. As of the enactment, there were only 11 surviving victims. To apply for compensation through the Victims of Eugenics Sterilization Compensation Fund, authorized through the 2015 Appropriation Act, claimants must complete and mail in an application form and provide supporting documentation to the Virginia Department of Behavioral Health and Developmental Services. An individual or lawfully authorized representative is eligible to request compensation under this program if the individual was involuntarily sterilized pursuant to the 1924 Virginia Eugenical Sterilization Act, living as of February 1st, 2015, and sterilized while a patient at Eastern State Hospital, Western State Hospital, Central State Hospital, Southwestern State Hospital, or the Central Virginia Training Center, formerly known as the State Colony for Epileptics and Feeble-Minded, now closed. On October 7, 2016, the Treatment of Certain Payments in Eugenics Compensation Act was signed by the President and became law as Public Law 114-241. This federal law provides that payments made under a state eugenics compensation program shall not be considered as income or resources for purposes of determining the eligibility of a recipient of such compensation for, or the amount of, any federal public benefit. California Sterilization Compensation Program. In 2003, the state of California formally apologized for its eugenics sterilization program that took place until 1979. This included apologies from Governor Gray Davis, Attorney General Bill Lockyer, and a resolution passed by the state Senate expressing profound regret over the program. In 2021, the California State Legislature passed Assembly Bill AB 137, creating the California Forced or Involuntary Sterilization Compensation Program, apologizing for sterilizations at state prisons, ordering the creation of memorial plaques, and allocating $4.5 million for financial compensation to those sterilized by the state. California's eugenic sterilization program began in 1909 with the passage of Chapter 720 of the Statutes of 1909, revised in 1913, Chapter 363 of the Statutes of 1913, and 1917, Chapters 489 and 776 of the Statutes of 1917. Which authorized medical superintendents in state homes and state hospitals to perform, quote, asexualization, end quote, on patients. This allowed medical personnel to perform vasectomies for men and salpingectomies for women who were identified as, quote, afflicted with mental disease which may have been inherited and is likely to be transmitted to descendants, the various grades of feeble-mindedness, those suffering from perversion or marked departures from normal mentality, or from disease of a syphilitic nature, end quote. The law passed unanimously in the state assembly and drew only one dissenting vote in the state senate in 1909. The subsequent amendments shifted the focus of the program from the castration of those imprisoned in state prisons and towards the sterilization of those held in state mental hospitals. California maintained 12 state homes and state hospitals that housed thousands of patients who were committed by the courts, family members, and medical authorities. While many sterilizations included the use of consent forms, such consent was often a condition of release from commitment. This, along with other conditions such as lack of full information, prevented true consent. Moreover, AB 137 notes that even though the law did not target specific racial or ethnic groups in practice, quote, labels of mental deficiency and feeble-mindedness were applied disproportionately to racial and ethnic minorities, people with actual and perceived disabilities, poor people, and women, end quote. For example, between 1919 and 1952, quote, women and girls were 14% more likely to be sterilized than men and boys, end quote. Quote, male Latino patients were 23% more likely to be sterilized than non-Latino male patients, and female Latina patients were 59% more likely to be sterilized than non-Latina female patients, end quote. California's eugenic sterilization law was repealed in 1979, but sterilization without proper consent continued in state institutions. In 2014, the California State Auditor released an audit of female inmate sterilizations that occurred in the state prison system's medical facilities between fiscal years 2005 to 2006 and 2012 to 2013. The auditor discovered 144 women imprisoned by the state were sterilized through bilateral tubal ligation, which is not medically necessary and is solely used for female sterilization. The auditor found that officials failed to receive informed consent in at least 39 of these cases, but more broadly expressed serious reservations about all of the procedures as they were, quote, unable to conclude whether inmates received educational materials, whether prison medical staff answered inmates' questions, or whether these staff provided the inmates with all the necessary information to make such a sensitive and life-changing decision as sterilization, end quote. Following this report, the legislature prohibited the sterilization for the purpose of birth control for any individual under the control of the California Department of Corrections and Rehabilitation, CDCR. There are an estimated 244 survivors of illegal prison sterilization. The California legislature passed and the governor signed AB 137 in 2021 and 22 legislative session. AB 137 created the California Forced or Involuntary Sterilization Compensation Program, which financially compensates survivors of state-sponsored sterilization. The California Victim Compensation Board, CalVCB, administers the program. AB 137 sets out specific criteria for those who can apply for compensation from the program. Quote, 1. Any survivor of state-sponsored sterilized conducted pursuant to eugenics laws that existed in the state of California between 1909 and 1979. 2. Any survivor of coercive sterilization performed on an individual under the custody and control of the Department of Corrections and Rehabilitation after 1979, end quote. To be eligible under the first category, a person must have been 1. Sterilized pursuant to the eugenics laws in place between 1909 and 1979. 2. Sterilized while the individual was at a facility under the control of the State Department of State Hospitals or the State Department of Developmental Services. 3. And alive at the start date of the program, July 1st, 2021. To be eligible under the second category, the following conditions must be met. 1. Sterilization procedures occurred after 1979. 2. Claimant was sterilized while in the custody of CDCR. 3. Sterilization was not required in an emergency life-saving medical situation or due to a chemical sterilization program for convicted sex offenders. 4. Sterilization was for birth control purposes. And 5. The claimant was sterilized under one of the following conditions: without consent given less than 30 days before sterilization, with consent given without counseling or consultation, and with no record or documentation of providing consent. The law also requires Cal VCB to affirmatively identify and disclose coercive sterilizations that occurred in California prisons after 1979 so that individuals may then apply for compensation. AB 137 allocated $4.5 million for direct financial compensation to applicants who met the above eligibility criteria. Each approved applicant receives an initial payment of $15,000 within 60 days of notice of confirmed eligibility. After all applications are processed and all initial payments are made, any remaining program funds will be disbursed evenly to the qualified recipients by March 31st, 2024. Applications to the program are accepted from January 1st, 2022 through December 31st, 2023. Sponsor of the bill, California Latinas for Reproductive Justice, summarized the rationale for the apology and financial compensation. California will become the third state to compensate survivors for forced sterilizations under eugenics laws, following North Carolina 2013 and Virginia 2015. It will also become the first state to compensate survivors of involuntary sterilizations performed outside of formal eugenics laws. Enactment of this bill would send a powerful message around the country that forced sterilizations will not be tolerated in carceral settings, including prisons, detention centers, and institutions. The bill specifically stated that financial compensation would not be subject to tax and other limitations. Notwithstanding any other law, the payment made to a qualified recipient pursuant to this program shall not be considered any of the following: 1. Taxable income for state tax purposes. 2. Income or resources for purposes of determining the eligibility for or amount of any benefits or assistance under any state or local means-tested program. 3. Income or resources in determining the eligibility for or the amount of any federal public benefits as provided by the Treatment of Certain Payments in Eugenics Compensation Act, 42 U.S.C. Section 18501. 4. Community property for the purpose of determining property rights under the Family Code and Probate Code. Moreover, the financial compensation shall not be subject to an enforcement of money judgment under the state law, a money judgment in favor of the Department of Health Care Services, the collection of owed child support, or the collection of court-ordered restitution fees or fines. In 2003, the state legislature, governor, and attorney general all issued formal apologies for the 1909 to 1979 eugenic sterilization program. Specifically, the state Senate passed a resolution expressing, quote, profound regret over the state's past role in the eugenics movement and the injustice done to thousands of California men and women, end quote, addressing, quote, past bigotry and intolerance against the persons with disabilities and others who were viewed as genetically unfit by a eugenics movement, end quote, recognizing that, quote, all individuals must honor human rights and treat others with respect regardless of race, ethnicity, religious belief, economic status, disability, or illness, end quote, and urging, quote, every citizen of the state to become familiar with the history of the eugenics movement in the hope that a more educated and tolerant populace will reject any similar abhorrent pseudoscientific movement should it arise in the future, end quote. In 2021, as part of the passage of AB 137, the state legislature formally expressed regret for the sterilizations that took place after 1979. Specifically, the legislature stated, quote, the legislature also hereby expresses its profound regret over the state's past role in coercive sterilizations of people in women's prisons and the injustice done to the people in those prisons and their families and communities." End quote. AB 137 also requires the State Department of State Hospitals and State Department of Developmental Services and CDCR, in consultation with stakeholders, to establish markers or plaques at designated sites. Stakeholders must include at least one member and one advocate of those who were sterilized under California's eugenics laws between 1909 and 1979, and of those who were sterilized without proper authorization while imprisoned in California state prisons after 1979. These memorials should, quote, "acknowledge the wrongful sterilization of thousands of vulnerable people under eugenics policies and the subsequent sterilization of people in California women's prisons caused, in part, by the forgotten lessons of the harms of the eugenics movement." End quote. The compensation program is administered by Cal VCB. The law gives Cal VCB 6 months from passage to have applications ready for the public, and applications are accepted from January 1st, 2022 through December 31st, 2023. Applications are available through Cal VCB's website, over the phone, through the mail, or by visiting in person, and they can be returned by mail, email, or fax. The individual submitting the application will receive a letter from Cal VCB either confirming a complete application or requesting additional information. Once the application is screened and deemed complete, the application will be considered for eligibility. The statute sets out eligibility criteria discussed above, and the specific documents and document types Cal VCB may use to determine eligibility. Upon completion of the eligibility review, a letter will be sent out with the determination. If eligibility is verified, the claimant will receive a confirmation letter, and they shall receive an initial payment of $15,000 within 60 days of the Cal VCB's determination. If eligibility is not verified, the application will be denied. Notification will be sent with the necessary appeal information. An individual may file an appeal to Cal VCB within 30 days of the receipt of the notice of decision, and after receiving the appeal, Cal VCB shall again attempt to verify the claimant's identity pursuant to statutory requirements. If the claimant's identity cannot be verified, the claimant can provide additional evidence, including but not limited to documentation of the individual's sterilization, sterilization recommendation, surgical consent forms, relevant court order or institutional records, or a sworn statement by the survivor or another individual with personal knowledge of the sterilization. Cal VCB has 30 days to rule on an appeal, and any successful appeals will receive compensation as above. After exhaustion of all appeals arising from the denial of an individual's application, but by no later than 2 years and 9 months after the start date of the program, Cal VCB shall send a final payment to all qualified recipients. This final payment shall be calculated by dividing the remaining unencumbered balance of funds for victims' compensation payments by the total number of qualified recipients. According to Cal VCB, as of December 20th, 2022, the program has received 309 applications. Of those, 45 have been approved, 129 have been denied, 3 have been closed as incomplete, and 159 are being processed. Experts estimate there may be about 600 people alive today that qualify for compensation, and the Cal VCB is undertaking several actions to try to spread the word about the program. This includes sending posters and fax sheets to 1,000 skilled nursing homes and 500 libraries, and distributing more than 900 posters to the state's 35 correctional institutions to post in common areas and housing units in hopes of reaching more people. The state also signed a $280,000 contract in May with JP Marketing to launch a social media campaign that will run through the end of 2023. The biggest push began in December 2022, when the state will pay for TV and radio ads in Los Angeles, San Francisco, and Sacramento that will run through October 2023. Chicago Police Department. Between 1972 and 1991, John Burge, a high-ranking officer in the Chicago Police Department led a group of detectives and officers in an organized operation to torture and abuse over 120 African American criminal suspects, with some cases resulting in coerced confessions. Investigations revealed that Burge led operations of abuse that included physical torture and psychological abuse, such as, quote, trickery, deception, threats, intimidation, physical beatings, sexual humiliation, mock execution, and electroshock torture, end quote. Evidence also suggests that judges and some city officials facilitated the abuse and its cover-up. Many of Burge's African American victims ended up in prison due to coerced confessions, and some were sentenced to death. Efforts to hold Burge accountable for his actions were unsuccessful because the statute of limitations had expired for many of the cases of torture. Community members sought alternative methods to obtain justice, and those efforts eventually led to the passage of the Ordinance for Reparations for the Chicago Police Torture Survivors, Reparations Ordinance. Years before the Reparations Ordinance was passed, community activist organizations in Chicago, including the Chicago Torture Justice Memorial, CTJM, and attorney Joey Mogul of People's Law Office, fought to have the harms inflicted by Burge and his officers acknowledged and the survivors compensated. They litigated torture cases in court seeking justice for the survivors. One of those survivors was Andrew Wilson, who had been sentenced to death because of the false confession Burge and other officers coerced from him using torture. Wilson filed suit under 42 U.S.C. 1983, seeking damages from Burge. An all-white jury found in favor of Burge, but the United States Court of Appeal for the Seventh Circuit reversed the verdict and ordered a new trial. Another survivor who sought relief through the courts was Aaron Patterson, who was sentenced to death. His claim against Burge was raised in a post-conviction petition, which asked the court to determine whether Patterson was a victim of torture. After denials in the lower court, the Illinois Supreme Court heard the case specifically to address whether evidence of physical injury was necessary to prove that a confession was coerced using torture. The Illinois Supreme Court held that proof of physical injury was not required to establish that a confession was physically coerced. There were two examples of the many cases where survivors pursued remedies through the courts with mixed results. Some claims were raised in post-conviction proceedings seeking damages, others were filed to address limited issues/questions, and other actions were filed seeking new trials based on the coerced confessions. The results varied, and the overall frustration of the survivors, their attorneys, and activists led them to seek support from international human rights organizations like the Inter-American Commission for Human Rights, Inter-American Commission, and the United Nations Committee Against Torture, to hold Burge and the City of Chicago accountable. They filed petitions with the Inter-American Commission and the Committee Against Torture, seeking redress. The Inter-American Commission did not take official action, but the Committee Against Torture issued a report affirming the survivors' position and urging the United States to provide redress, quote, by supporting the passage of the ordinance entitled Reparations for the Chicago Police Torture Survivors, end quote. In its report, the Committee Against Torture expressed concerns that no police officer had been convicted for their crimes and that the majority of victims still had not received, quote, compensation for the extensive injuries suffered, end quote. Although Burge was convicted for perjury and obstruction of justice, there was not sufficient evidence to prosecute him for violating the constitutional rights of the survivors. In May of 2015, the efforts of the survivors, their attorneys, and the activists culminated in the Chicago City Council, quote, approving a municipal ordinance giving reparations to Burge torture survivors, end quote. The reparations ordinance approved a $5.5 million fund that would be used to award each survivor $100,000 in financial compensation, along with non-financial reparations such as psychological counseling, health care, and an official memorial. The ordinance was drafted by attorney Joey Mogul, who worked with survivors, their families, and other activists. There was no temporal limit for filing claims. The intended recipients of the reparations ordinance included all torture survivors that have credible claims of torture or physical abuse at the hands of John Burge or his subordinates, their immediate family members, and in some cases to their grandchildren. The ordinance requires the individual must have a credible claim of torture or physical abuse by John Burge or one of the officers under his command between May 1st, 1972 and November 30th, 1991. The reparations ordinance intended to fully address the harm Burge and his subordinates caused by providing for a formal apology, financial compensation, services and support for survivors, funding for public education, and a memorial. First, the formal apology acknowledged the extent of the police abuse and admitted that the city of Chicago and other public officials were complicit in the abuse of over 100 African Americans. Second, each survivor with a credible claim of torture or abuse by Burge or one of the officers under his command would receive financial reparations of $100,000. The ordinance created the Chicago Police Torture Reparations Commission, which was responsible for disbursing financial reparations to the survivors. Third, the ordinance provided survivors and their families free tuition at the city colleges of Chicago and free access to job training. Fourth, in addition to financial and educational reparations, the ordinance also provided psychological services to survivors and family members at a dedicated community center. Finally, the city of Chicago promised to work with the activist group CTJM to, quote, construct a permanent memorial to the Burge victims, and beginning in the 2015-2016 school year, the Chicago Public Schools would incorporate into its existing U.S. history curriculum for 8th grade and 10th grade students a lesson about the Burge case and its legacy, end quote. The claims process for obtaining reparations under the ordinance began with CTJM providing the City of Chicago with a list of individuals CTJM determined were eligible for reparations. Both the City and CTJM would investigate the claim, and if both parties agreed the survivor had a credible claim, the survivor would be entitled to the financial reparations from the fund. If CTJM and the City disagreed about an individual's credibility, that individual would have the opportunity to present information and evidence to an independent arbitrator who would make a final and binding decision. The only remaining unfulfilled reparation is the memorial. This is in part because the reparations ordinance did not specify the timeline for the memorial and specific funding was not provided. As of 2021, the memorial still has not been built, but individuals at CTJM have been meeting with the mayor and remain hopeful the process for building the memorial will start soon. Evanston, Illinois. The city of Evanston passed a racial equity scheme, the Restorative Housing Program, 37R27, in March 2021 to redress the city's discriminatory practices in housing, zoning, and lending that created a wealth and opportunity gap between white and African American Evanstonians. Under this scheme, African American Evanstonians, their descendants, or other residents who experienced housing discrimination by the city of Evanston are provided up to $25,000 to either purchase a home, conduct home improvements, or pay down their existing mortgage. On March 27, 2023, the City Council unanimously added direct cash payments as a fourth option. The Restorative Housing Program was the first reparatory program enacted by the city, but Evanston has also studied its discriminatory past and produced a report, created a city reparations fund, honored local historical African American sites, and issued an apology. The City Council enacted the Restorative Housing Program to redress the injustices found in the report commissioned for the City Council's Reparations Subcommittee. Evanston policies and practices directly affecting the African American community, 1900 to 1960 and present. According to the report, quote, The city of Evanston officially supported and enabled the practice of segregation, end quote, by passing a zoning ordinance in 1921 that condoned implicit race-based housing segregation, demolishing homes owned by African American families for economic development on the grounds that they were, quote, unsanitary, end quote, or, quote, overcrowded, end quote, providing permits to Northwestern University to develop temporary segregated housing for veterans after World War II, segregating post-World War II temporary housing for veterans, and failing to enact a fair housing ordinance to outlaw housing discrimination until the late 1960s. The Restorative Housing Program was created in March 2021 with the aim of increasing African American homeownership in order to revitalize and preserve African American owner-occupied homes in Evanston. To be eligible, the home must be located in Evanston and be the applicant's primary residence. The program has 3 categories of intended recipients: Evanston residents over the age of 18 years of Black African American ancestry, and in order of priority either 1, an ancestor, a resident who lived in Evanston between 1919 and 1969, was at least 18 years old during that time, and experienced housing discrimination due to the city's policies and practices. 2, a direct descendant of an ancestor, child, grandchild, great-grandchild, and so on. Or 3, a resident that does not qualify as an ancestor or direct descendant but experienced housing discrimination due to city ordinance, policy, or practice after 1969. The city manager's office is primarily responsible for administering this program. The city manager's office takes in applications and verifies eligibility based on the guidelines established by the Reparations Committee discussed below. At the close of the first round of applications, 122 ancestor applicants were verified by the city and 16 were randomly selected on January 13, 2022, via the city's lottery to receive the first round of payments. In March of 2023, Evanston planned its second round of disbursements for 35 to 80 ancestors. Upon approval by the City Council, funds are sent electronically or via check to the closing agent for dispersal when the applicant closes on a home purchase, to the contractor upon receipt of invoice, or to the lender for mortgage payment. City Council selected this method of fund disbursement due to Internal Revenue Service, IRS, reporting requirements. The city lacks the requisite authority to exempt direct payments from either state or federal income taxes. Consequently, a recipient would be liable for the tax burden associated with the award. A recipient could end up being required to pay between 24 to 28% to the IRS and Illinois. By distributing payments to the financial institutions or vendor instead of the Evanston resident, the financial institution or vendor becomes responsible for the tax liability. For the direct cash payment option that was added to the Restorative Housing Program in March 2023, the Law Department of the City of Evanston determined that payments made under the, quote, general welfare exclusion, end quote, will not qualify as taxable income. Accordingly, applicants who wish to utilize the cash payment option must be income qualified in order to avoid tax liability and must receive a grant from the General Welfare Fund. For the other 3 grant options in the Restorative Housing Program, contracts are paid in installments, with half of the money arriving up front, a quarter halfway through the job, and the final quarter upon completion. Approved funds must be utilized within the year of approval. Funding can be layered with other housing assistance programs by the city, state, or federal government. Evanston's recent movement for reparatory justice began in 2019. Former Evanston alderperson Robin Rue Simmons led the charge for reparatory justice with the support of the city's Equity and Empowerment Commission. First, the commission studied the discriminatory past of the city by enlisting the help of 2 Evanston-based historical organizations, the Shorefront Legacy Center and the Evanston History Center, to identify past harms inflicted against African American Evanstonians. These organizations produced a draft report that provided justification for the enactment of a racial equity scheme by listing historical and contemporary instances where the city of Evanston might have facilitated, participated in, enacted, or stood neutral in the wake of acts of segregated and discriminatory practices. The report described Evanston's historic segregated practices in transportation, public spaces, and employment, delayed desegregation efforts, and housing and zoning policies that led to overcrowding, higher rents, and segregated inferior housing for African American residents. The Commission also held community meetings to gather public input and recommendations to the City Council. Both the National Coalition of Blacks for Reparations in America, NCOBRA, and the National African American Reparations Commission, NARC, provided advice regarding Evanston's reparatory process. Additional town halls and meetings were hosted by the city to further engage residents in program specifics. In November 2019, Evanston adopted Resolution 126R19 to study community recommendations for, quote, repair and reparations, end quote, and create the City Reparations Fund to collect tax revenues. Resolution 126R19 committed the first $10 million of the city's municipal cannabis retailers' occupation tax, 3% on gross sales of cannabis, to fund local reparations for housing and economic development programs for African American Evanston residents over the course of 10 years. Individual residents, churches, and local businesses can also donate to the City Reparations Fund. Following the establishment of the funding source, Evanston formed a permanent reparations subcommittee and hosted several town hall and subcommittee meetings to solicit feedback on the structure of local reparations. In June 2020, the Evanston Preservation Commission of City Council passed Resolution 54R20 to preserve and honor historical African American sites in Evanston's 5th Ward. In November 2022, the City Council passed a resolution to delegate $1 million annually from the graduated real estate transfer tax collected from all property purchased above $1.5 million to the City Reparations Fund for a period of 10 years. An additional funding recommendation came in late November 2022 when the City Council proposed to pass Resolution 125R22 to transfer $2 million from the city's general fund to the Reparations Fund. Prior to creating a racial equity scheme, the City Council of Evanston created the Equity and Empowerment Commission in 2018 to address systemic inequalities and adopted Resolution 58R19, quote, commitment to end structural racism and achieve racial equity, end quote. In Resolution 58R19, Evanston City Council, 1, apologized for the damage caused by its history of racially motivated policies and practices, such as zoning laws that supported neighborhood redlining, municipal disinvestment in the African American community, and a history of bias in government services. 2, declared itself an anti-racist city. And 3, denounced white supremacy. The resolution begins with findings laying out the foundation for an apology and then proceeds with a series of pronouncements against anti-black racism. Now, therefore, be it resolved by the City Council of the City of Evanston, Cook County, Illinois, that in accordance with the fundamental principles set forth in the Declaration of Independence, which asserts as a fundamental basis that all people are created equal and are endowed with unalienable rights of life, liberty, and the pursuit of happiness. Section 1. The City Council of Evanston hereby acknowledges its own history of racially motivated policies and practices, apologizes for the damage this history has caused the city, and declares that it stands against white supremacy. To receive funds from the Restorative Housing Program, interested applicants must provide proof of eligibility based on the sample list of documents cited in the program guidelines. To prove ancestor eligibility, the applicants must provide documentation of their age, race, and residency. To prove direct descendant eligibility, applicants must provide documentation of age, race, and relationship to an ancestor via birth certificate, marriage record, hospital record of birth or death, yearbook, or other means. To prove eligibility based on discrimination as a resident, applicants must show proof of age, residency, and the city ordinance, policy, or procedure that served to discriminate against the applicant in the area of housing. Issues of funding, restrictive eligibility and spending, distribution, and other criticisms arose during the implementation of Evanston's restorative housing program. First, the cannabis tax has not generated enough revenue to provide payments to all eligible applicants. When the City Council drafted the resolution, it expected 3 cannabis stores to open in Evanston. However, so far only one has opened. In late 2022, the city secured alternative sources of funding to supplement the cannabis tax, the graduated real estate transfer tax, and the general fund. Additionally, community members and business contribute private donations to the Reparations Community Fund. Funding restrictions have also been a critique of the Evanston Racial Equity Scheme. Only ancestors who currently reside in Evanston are eligible, leaving out many African American homeowners who were victims of Evanston's discriminatory policies but moved away. Alderman Peter Braithwaite, 2nd Ward, chair of the Reparations Committee, said that restricting reparations to current residents was necessary because of the city's limited staff and resources. Other residents complained that funding was too narrowly constrained to housing-based projects, ignoring other potential needs for reparatory justice. In response, leaders stated that the housing program was only the first of many reparatory justice programs to come, and housing was identified as the most urgent need among those who attended the public subcommittee and town council meetings. As an example of the funding's restraints, 2 of the 16 selected in the first round of applications for funding did not own property and almost lost the funds. On March 2, 2023, the Reparations Committee approved the direct cash payment for those 2 ancestors. Less than 1 month later, the City Council approved an option to provide direct payment to all reparations recipients. Another issue in the disbursement process is that many residents believed the money should have gone directly into the hands of the eligible and not to the banks who facilitated racial discrimination in the first place. To address this concern, the city hopes to provide a resource guide for grant recipients with a list of black banks, banks with a history of fair lending, and a directory of black contractors, realtors, real estate attorneys, appraisers, and surveyors that fund recipients can hire. Many residents have complained that the pace of the racial equity scheme is too slow. 7 ancestors died before they were selected for restorative housing grants. The Reparations Committee added a requirement for ancestors to name a beneficiary to pass down the rights of the grant once they have been awarded. Finally, some experts critiqued the Evanston Reparatory Program as being piecemeal and potentially distracting from the priority of a comprehensive national reparations program. Economic and public policy experts William A. Darity Jr. and A. Kirsten Mullen objected to the Evanston program's restrictions on funding, preferring unrestricted direct payments, and said that the program did not go far enough to address the huge racial equity gap between black and white Evanston residents. They also said that Evanston's municipal government lacks the budget necessary to adopt an adequate reparations proposal, which would require $3.85 billion to close the $350,000 per capita racial wealth gap. Asheville, North Carolina. The city of Asheville, North Carolina unanimously passed Resolution 2128 on July 14, 2020, to consider reparations for the city's participation in and sanctioning of the enslavement of black people, its enforcement of segregation and accompanying discriminatory practices, and carrying out an urban renewal program that destroyed multiple successful black communities. Asheville has formed a reparations commission which anticipates presenting a final policy recommendations to be voted upon by August 30th, 2023, and submitting a written report by October 31st, 2023. Only 2 recommendations have been made as of May 2023. 1, to provide funding in perpetuity, and 2, to request a third-party audit of the City of Asheville and Buncombe County to ensure harms done to Black residents are stopped. According to Resolution 2128, the Reparations Commission intends to address the following harms to Black people: unjust enslavement, segregation and incarceration, the denial of housing through racist practices in the private realty market, including redlining, steering, blockbusting, denial of mortgages, gentrification, discriminatory wages paid in every sector of the local economy regardless of credentials and experience, the disproportionate unemployment rates and reduced opportunities to fully participate in the local job market, systemic exclusion from historic and present private economic development and community investments, segregation from mainstream education and within present-day school programs, denial of education through admissions, retention, and graduation rates of every level of education in Western North Carolina, and through discriminatory disciplinary practices, historic and present inadequate and detrimental health care, unjust targeting by law enforcement and criminal justice procedures, incarceration at disproportionate rates, and subsequent exclusion from full participation in the benefits of citizenship that include voting, employment, housing, and health care, disproportionately forced to reside in, adjacent to, or near brown zones and other toxic sites, disproportionately limited to confined routes of travel provided by public transportation, and disproportionately suffering from isolation of food and child care deserts. Asheville did not provide any specific timeline of the harms the Reparations Commission is intended to address. Resolution 2128 states that the Reparations Commission will make short, medium, and long-term recommendations to, quote, make significant progress toward repairing the damage caused by public and private systemic racism, end quote. The resolution takes the Commission to issue a report so the City of Asheville and local community groups may incorporate it into their short and long-term priorities and plans. The resolution states the, quote, report and the resulting budgetary and programmatic priorities may include, but not be limited to, increasing minority home ownership and access to other affordable housing, increasing minority business ownership and career opportunities, strategies to grow equity and generational wealth, closing the gaps in healthcare, education, employment and pay, neighborhood safety, and fairness within the criminal justice, end quote. The city manager and city staff have recommended a 3-phase process that includes information sharing and truth-telling, formation of the Reparations Commission, and finalization and presentation of the report. Phase 1 occurred from May 2021 to June 2021 and was intended to provide a better understanding of policy impacts and where those impacts occurred, identify and understand current disparities and areas that need focus, identify barriers to address generational wealth, and inspire our community to identify collaborative opportunities to create a more equitable Asheville. During Phase 1, 3 events were held in June 2021, namely 3 information sharing and truth-telling speaker series regarding past policies and practices, present trends and disparities, and future initiatives. The information from this speaker series was used to inform the development of the Reparations Commission and its scope of work. Phase 2 was the formation of the Reparations Commission, which will address disparities in housing, economic development, public health, education, public safety, and justice. The city announced on March 8, 2022, the approval of 5 members for the Reparations Commission appointed by the Asheville City Council, as well as 15 members and 2 alternates appointed by the historically impacted Black neighborhoods. The commission members are serving off 5-year Impact Focus Area, IFA, work groups. criminal justice, economic development, education, health and wellness, and housing, which are responsible for analyzing information on these areas and reporting key findings to the full Commission. As of the publication of this report, the Commission is in Phase 3, but according to documents from the January 9, 2023 Commission meeting, the priorities are no longer short, medium, and long-term recommendations, but rather feasibility and community impact. The documents also reflect an updated timeline with 10 different activities, the last 6 of which are slated to occur in 2023. Reaffirm the resolution and commission role, develop IFA recommendations by May 31st, community engagement and input by May 31st, recommendation vetting and refinement by July 31st, present recommendations for commission voting by August 30th, and submit written report and close project by October 31st. The documents reflect a few draft recommendations, but no final recommendations have yet been presented. On June 8, 2021, the Asheville City Council voted to allocate $2.1 million of the city's proceeds from the sale of city-owned land, a portion of which includes land the city purchased in the 1970s through urban renewal, a policy that, quote, resulted in the displacement of vibrant black communities and the removal of black residents and homeowners, many into substandard public housing, end quote. The city anticipates that of the $2.1 million, $200,000 will fund the Reparation Commission's planning and engagement process, leaving approximately $1.9 million in initial funding for reparations. Asheville's reparations scheme has not gone without any criticism. Economic expert William A. Darity stated that he was, quote, deeply skeptical about the local or piecemeal actions to address various forms of racial inequality being labeled reparations, end quote. Darity has written that reparations would, quote, have to close the pre-tax racial wealth disparity in the United States, which would cost about $10 to $12 trillion, end quote, in order to be effective. Darity further notes that the, quote, piecemeal reparations taken singly or collectively at the state and municipal level cannot meet the debt for American racial injustice, end quote. With respect to the local community, reactions have been mixed. During the virtual meeting at which the reparations resolution was passed, a resident of Montford, North Carolina, quote, argued that the city's black police chief, city manager, and council members are an indication that blacks can succeed in Asheville. So to dump this all on us, white folk, I think is offensive, end quote. Conversely, a resident who identifies as white stated, quote, white people, we have to realize that we are complicit and our souls are in jeopardy, end quote. A number of news articles have been written about Asheville's reparations scheme. Bloomberg noted, Asheville's reparations are not focused on slavery or redlining, though it was not innocent of either, but rather on its participation in what was considered one of the largest urban renewal projects in the South, if not the country. Throughout the 1960s and 1970s, Asheville's clearance of areas considered blighted ended up displacing thousands of black Ashevilleans, stripping them of their land, business, and properties without recompense. According to local historian Wesley Grant, one black neighborhood alone, East Riverside, lost, quote, more than 1,100 homes, 6 beauty parlors, 5 barber shops, 5 filling stations, 14 grocery stores, 3 laundromats, 8 apartment houses, 7 churches, 3 shoe shops, 2 cabinet shops, 2 auto body shops, 1 hotel, 5 funeral homes, 1 hospital, and 3 doctor's offices, end quote. Most of the black families and workers displaced ended up living in housing projects, mostly cut off from the rest of Asheville society and its growing economy. Bloomberg further noted that Asheville's reparations schemes will be a, quote, community reparations model, end quote, which means that instead of making direct payments to individuals, Asheville will look for areas within the city's budget to add resources to address the racial disparities that persist today. The city manager will also work with surrounding Buncombe County and other community stakeholders to define what reparations will be. Accordingly, the exact form of reparations will remain unknown until the issuance of the final report in 2023 and eventual adoption of specific reparations measures. Providence, Rhode Island. After the murder of George Floyd in the summer of 2020, the mayor of Providence, Rhode Island signed an executive order to launch a, quote, truth and reconciliation and municipal reparations, end quote, process to, quote, eradicate bias and racism, end quote, against its black and indigenous residents and other people of color. Following that three-part process, the city has issued a formal apology and enacted a 2023 city budget, which includes $10 million earmarked for reparatory programs, but does not include direct cash payments solely to African Americans or descendants. Beginning with a truth-telling phase, the Rhode Island Black Heritage Society collaborated with city and state historical institutions to publish a 200-page report titled A Matter of Truth: The Struggle for African Heritage and Indigenous People Equal Rights in Providence, Rhode Island, 1620 to 2020. The report documents the history of harm that Providence sought to remedy, including the lasting wounds caused by slavery, the genocide of indigenous people, and the ongoing racial discrimination from 1620 to 2020 throughout the city of Providence and the state of Rhode Island. In the reconciliation phase, the Providence Cultural Equity Initiative and Roger Williams University published a report detailing their efforts to survey Providence community members, develop guiding principles for reparations, and develop a model and proof of concept to continue reconciliation in perpetuity, including through a multimedia initiative. For its guiding principles on reconciliation, the Reconciliation Report noted the need for ongoing communal learning, a focus on particular people, places, and the importance of efforts to cross barriers of identity and empathy. The city's reconciliation principles also rejected depictions of participants that reduced them to racialized categories or tropes, while celebrating resilience both past and present. Finally, Providence's reconciliation principles underscored action, emphasizing a community-owned but institutionally supported process, and the principle that reconciliation cannot be accomplished without reparations. In the third and final phase, labeled Reparations, the mayor of Providence signed an executive order creating the Municipal Reparations Commission, consisting of 13 members from the local community. The commission held over a dozen public meetings, discussing the justifications for reparations and the form they may take. Among other things, presenters at the public meetings discussed the international framework for reparations and its 5 elements, as well as international treaties and reports, including the Universal Declaration for Human Rights, the International Convention on the Elimination of All Forms of Racial Discrimination, which the United States ratified in 1994, the Civil Rights Congress's presentation to the United States for the relief of crimes against humanity by the United States government, and a UNESCO publication titled Healing the Wounds of Slave Trade and Slavery. Following its public hearings, the Commission published a report listing its final recommendations for an 11-point reparatory program. In its recommendations, the Commission defined, quote, reparations, end quote, as, quote, closing the racial wealth and equity gap between Providence residents and neighborhoods, end quote. When defining the communities eligible for its reparatory programs, the Commission identified indigenous people, African heritage people, Providence residents facing poverty, and Providence residents living in qualifying census tracts and neighborhoods. While the latter 2 categories, residents facing poverty and those in qualified census tracts, include Providence residents of any race, The Commission included those categories of eligibility to comply with limitations imposed by federal funding, as the city was relying upon federal COVID-19 relief as a source of initial funding for its repertory program. In November 2022, the mayor of Providence signed a city budget allocating $10 million provided to the city from the American Rescue Plan Act to fund programs across 7 of the Commission's recommendations. While some Commission and community members expressed concern that $10 million would be insufficient to redress the harms identified in the Truth Report, others observed that the $10 million represented a start to the repertory programs, not the end, and that once the programs were enacted, future funding could be drawn from other public and private sources. The mayor of Providence also issued an executive order recognizing and apologizing for the city's role in discriminating against African heritage and indigenous people. The order apologizes for the city's role in, quote, discriminatory practices, including lack of equal access to public education, voting rights, and general civil rights that led to the subjugation, enslavement, detribalization, death, and control of African heritage and indigenous people in past and present day, end quote. The order also apologizes for Providence's actions after King Philip's War, where city leaders transferred captured and surviving indigenous people into slavery in the West Indies. The order further apologizes for the systemic harm enacted upon African heritage and indigenous communities through school segregation, unjust incarceration, police use of force, family destabilization, employment discrimination, warning outlaws, deliberate denials of public assistance, including redlining policies, and the city's failure to intervene in the destruction of African heritage and indigenous neighborhoods and communities, including during the riots in the 1980s. And that will conclude tonight's reading of Chapter 15 of the California Reparations Task Force's final report. I thank you for your time and your attention. Before you go, if you haven't done so already, please remember to like this video, hit the bell for reminders, and subscribe to our YouTube channel. When you go, please remember to get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, and X, formerly known as Twitter, at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and information on our Get Involved page. Get involved. Support our work by volunteering and/or donating. To donate, just click the Donate tab on the home page of our website. A special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. Learn more about their amazing work at www.cabwhp.org. A special thanks to Chris Lodgson for his leadership focus and his confidence in us as volunteer readers. It has been an honor, and I eagerly look forward to the next reading on next Thursday with a different volunteer. Please share our information with your family, friends, and colleagues. Thank you so much for joining us. Please remember to return next Thursday to hear from the next volunteer for Chapter 16. We at CJEC are honored you've joined us, and we appreciate you all. We are closer to reparations than we have ever been in California. Have a great night.